Hey! All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice D'Angelo. To my left, Justice Toone. We will be hearing 5 cases this morning. The rules are as they always are, so those of you who have been here before know them. It's 15 minutes per side with no rebuttal. We have read your briefs with some care and are very familiar with the facts. If you would therefore, it might be best to just jump into your argument, although the time is yours, and you may do with it as you wish. And with that, we will hear the first case, number 24-938, and this is Commonwealth versus, it's partially impounded. Is the name impounded? No? This is Commonwealth versus Atwary. And we will hear first from Attorney Rotondo.
Good morning, Your Honors. Attorney David Rotondo for Mr. Atwary. In this case, as you know, the defendant was pulled over for a civil motor vehicle infraction, tinted windows, and making an abrupt turn. I would like to point out, some of the facts that I think are that we need to focus on. The officers testified that, they're in a high crime area. However, I would like to point out that it was 9:15 in the morning and during the daylight hours on a very busy street. The officers did approach the vehicle in an unguarded position without their weapons drawn. We have to look at the totality of the circumstances here, and I would argue that at that point, there was not a heightened sense of, create a heightened awareness of a safety concern at that point.
I don't understand your making reference that they did not go to the car with their weapons drawn?
Yes.
So if it was at night in a very high crime area, making a motor vehicle stop, police could approach the car with their weapons drawn?
Well, I think if they did not approach the car with their weapons drawn, I think we can,
is it permissible for officers on a motor vehicle stop, for tinted windows, speeding, anything, to approach a car with their weapons drawn when they know nothing else?
When they're testifying it's a high crime area, it's possible. I'm not saying it's procedure, but
I'd like you to tell me one case where the SJC or our court has ever said that that is justifiable. On a motor vehicle stop, knowing nothing else, to approach a car with guns drawn, I think there'd be a problem if they had done that.
Right.
So if there's a problem, how can we use that as a factor that they didn't do that?
Well, I do not have a case. Okay. So if I can...
Was this before they had seen the alleged furtive movement or after?
That was before.
So if their fear is caused by the furtive movement, why would they have been acting afraid before the furtive movement? Maybe you should move temporally forward.
I can move on from that, Your Honor. I'd also like to point out that Officer Duckton approached the driver's side. Now, Officer Duckton, the Commonwealth has the burden. And Officer Duckton wasn't available to testify in this case. Now, he was the officer that approached the driver's side. Officer Bissonette approached the passenger side, and as you know from the facts, he testified he could only see shadows. However, it was clear enough that he could see Atwary reaching towards, to the passenger seat floor. So I think it's our position that even if the exit order in this case was justified, the search of the vehicle is not supported by specific and articulable facts to believe the suspect was dangerous, armed and dangerous, or suspected of any types of criminal activity. I realize it's a low burden for an exit order. However, to continue that exit order, based on the fact that, there was no firearm in plain view from outside the vehicle, Bissonnette testified he only observed the firearm after he opened the door and looked under the seat. And I would just like to point out that the cases that I have read, and most of the cases have, seem to require something more concrete than nervousness and ambiguous movements, especially in this case where the officer is, testifying that he saw shadows, he really couldn't see in there, but he was certain that, he was moving towards
the
under the seat.
credibility of his testimony isn't for us, it was for the judge below, right?
That's correct.
Did the judge ever rule on the search?
I'm sorry?
Did the judge ever issue a ruling on the search?
A ruling on the search?
Yes. Did he
Yes.
speak to? Yes.
I believe he stated that the search was, no, I'm sorry, Your Honor. I believe he was silent on that aspect of it.
It was never brought up again. Judge, what's your ruling? Judge, you said you're going to rule on this.
I don't believe,
Nothing like that.
I don't believe so.
Is it an implicit ruling because it was allowed in? I don't understand the status of what happened, because the judge says, oh, I'm gonna look into this about opening the door, I'll get back to you, and that's the end of the record as far as we can tell.
Yeah, from my recollection of the facts, Your Honor, he never made a specific finding on the legality of the search. I believe he said he was going to do that, but it never came to fruition.
Okay. But it came into evidence.
Sorry?
The evidence of the gun came into evidence.
Yes, it did,
Right,
it
okay.
did.
With no objection at trial?
Yes.
Okay.
Counsel, what about the fact that at least the judge seems to credit that or there's testimony that the defendant didn't follow the officer's orders to keep the tinted windows down? Is that something that can heighten an officer's fear for safety, especially after there's movement in the car?
Yes, I would agree. I would agree that may be have something to do with the defendant being nervous. Also, in this case, we really don't know what Officer Ducton observed. I mean, he had a clear view into the car. So, really our...
But the Commonwealth doesn't have to call it. They're met their burden by the other officer. I presume the defendant, if felt that officer had relevant testimony, it would have at least been permissible for the defendant to try to call that officer and didn't. So we're left with the other officer, and what I'm trying to follow is if there's a fear that there might be a weapon under a seat or where the defendant at least leans or goes over to, the fact that there's tinted windows and the defendant isn't keeping the window down so the officers can see in, that's added information that seems to make at least the exit order valid. Would you agree with that?
Yes.
So if the exit order is valid, certainly maybe there was a frisk, I don't know. I actually think there was and they didn't find anything. But doesn't the, quote, inherent mobility of the car make it permissible for the officers to search the interior of the car at that point for a weapon?
Well, I would say no, just based on the fact that I think the testimony was that the window went up and down a couple of times. But I would say no at that point.
If the exit order is okay, because they're in fear that maybe he put a gun on the floor, don't we have cases saying that since he's going to return to the car, they can do what some people call a pat frisk of the car, what's actually technically a protective sweep of the car limited to the places from which the driver could retrieve a gun?
Yes, there are. And, I believe we have to accept, the testimony of Bissett. However, in the case law, to justify the exit order, there was always additional factors that there was reasonable belief that there was, the suspect was dangerous, or the suspect had a criminal record, or the defendant, matched an individual armed from a call that they received, outstanding warrants. Every case I've read, there was something more than what we have in this case. And that, that is essentially my position, that the case falls short. That's all I have. Thank you.
Okay, I think we understand your argument. Thank you very much. Very good argument. We will hear next from Attorney Kennedy.
Ann Kennedy, Assistant District Attorney for the District Attorney's Office for the Middle District. This court should affirm the convictions, the defendant's convictions in this matter. The motion judge correctly denied the defendant's motion to suppress as the exit order as well as the protective sweep.
How did he deny it?
I did want to correct a couple of points. In the original motion after the hearing, he made his findings and said that he was going to look into the search. And then there is a transcript that this court has dated October 13th, 2023. And on that, pages 4 to 5 is where he denies the motion outright.
Right.
He specifically states that he finds the officers credible. He also specifically states why he was denying the motion based upon the various factors with respect to the reason for the exit order and the search of the car. He does not specifically state, I find the search valid, but he denies the motion to suppress on all matters.
Is it your view that if there's enough to justify the exit order, then there's enough to justify the protective search of the car? Is there ever any, do you ever need any additional evidence to do that?
I think with respect to that, you need to look at the facts, and the reason why I'm saying that is they can only go to the area where they suspect a weapon to be. So in this particular instance, yes, the information that was sufficient to justify the exit order was also sufficient to justify the limited intrusion of opening the passenger car door where they saw where the police testified. Officer Bissonnette testified that he saw the defendant reach. It's exactly where he looked and exactly where he found a gun.
If an officer has a fear for his safety or her safety, wouldn't it be logical that the first thing the officer does is pat frisk the defendant when they get the defendant out of the car?
The way this occurred was that Officer Bissonnette was approaching the passenger side, and then the other officers were approaching the defendant. They ordered him out of the car. It seemed to me, based on the way the transcript read, is it was simultaneous that he found that at that point he opened it, found the gun, and told them. So I'm not sure, there's no testimony as to whether or not a pat frisk would have occurred prior to that or not. But
It didn't.
No. What I am trying to say is that it looks as if this was all kind of occurring simultaneously.
They didn't pat frisk him until they put cuffs on him.
Exactly. They didn't pat frisk him until they put cuffs on him, but that's because at the moment that the other officers were approaching the driver and ordered him out, that's when Bissonnette opened the door. So they ordered him out, Bissonnette sees the gun.
So you think he was still in the car, not all the way out, when the officer said there's a gun?
I do not know. I think he was out of the car at that
So
point.
why hadn't they, to go to Judge D'Angelo's question, if they thought there was, this person had been armed a moment ago, presumably the first thing you do is pat frisk them to make sure there are no more weapons.
Presumably, yes, but again, this was all happening with, you have two police officers on one side, one police officer on the other side. I don't know the speed with which he opened the door and looked for the gun, or the speed with which there was a pat frisk. That being said, that they didn't pat frisk did not mean that they could not open the door and look for the weapon.
No, I think what Justice D'Angelo is getting at is that, of course, the subjective fear of the police is not immediately relevant. That's not the question. It's an objective test. But they were right there, and their behavior might reflect what objectively a person would have thought was going on, and they don't seem to have, again, I hear what you say about timing, but there's no suggestion that they were in such fear that they immediately pat-frisked this guy, and they were giving the exit order presumably because they'd seen him reach over and thought it was a gun being
They gave the exit order, and then, again, they're approaching it at the same time. I guess I just...
I don't know if I agree with that when I read the judge's findings of fact, page 8 of your brief. Officer Duncan and Officer Higgins asked the defendant to step to the rear of the motor vehicle. Again, I would assume, and maybe I'm wrong, I'm not a police officer, if you're in fear for your safety that the defendant might have a gun, you say, get out of the car, and as soon as he gets out of the car, you frisk him. You don't say, hey, walk to the back of the car, because while he's walking to the back of the car, if he has a gun, he could pull it on you.
Well,
I understand what you're saying, that maybe while he's walking to the back of the car,
exactly,
the officer then is searching. But again, it seems to me proper procedure would be, if you're in fear, as soon as the defendant gets out of that car, frisk him. Don't move your hands and frisk him. But wouldn't...
With respect to that, I think it was the reaching to the passenger side that caused, and it was Bissonnette who testified about the fear. And Bissonnette, it doesn't have to be every single officer present that is in fear, right? I don't look at it that way. It's a reasonable belief, a reasonably prudent person in the officer's position would be warranted in the belief that there was a fear for their safety. And the objective piece of going right to that spot, and that limited scope intrusion was sufficient in this circumstance for the officer to have conducted that limited search and for the motion judge to have denied it, given the other factors involved in this matter. If there are no further questions, the Commonwealth will rest on its brief.
Thank you very much. Very good argument. The case is submitted. The next matter we will hear this morning is, making sure I'm doing this in the right order, Commonwealth versus Jones, number 24713. And we will hear first from Attorney Malm.
Good morning, Your Honors. May it please the Court. Matthew Malm for the appellant, Mr. Jones. So numerous issues were raised in the brief. I'll begin discussing the Hertz records, the admission of the Hertz records. So in this case, the trial judge admitted Hertz records showing that my client was the renter of the vehicle over his objection. This evidence was crucial to the case. It was the only undisputed evidence linking him to the car in which the firearm was.
Hasn't the Commonwealth confessed error with respect to this?
They have, Your Honor.
Okay. You might want to focus on what remains of the case.
Understood, Your Honor. So I'm happy to answer any questions on that
No,
issue.
well, of course we have to independently.
If there are no questions, I'll move on to my next issue I'd like to discuss. Thank you. The next issue, Your Honor, would be the peremptory strike. Or the failure of the trial judge to excuse for cause juror number 16, which led to the defense attorney having to exercise a peremptory strike that she later established she would have used on someone later in the trial. The issue here, Your Honor, is okay. So I'll start just by reciting the facts briefly. So the question put to juror 16 was, do you believe that African Americans are more likely to commit crimes than white people per capita? The answer, no, it depends where you live.
That's the question. We don't know whether that's, those are the words that are used, but based on a cold record, it could have been no. It depends on blah, 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 blah. And it comes down to, does that make it ambiguous? Doesn't it? Is that answer ambiguous? That's what it really comes down to.
Yes, Your Honor. And here, it's clearly ambiguous. Apparent from the reaction.
No wasn't ambiguous.
Apparent from the reaction from both counsel. So defense attorney, prosecutor suggests, Judge, I think you should follow up on that answer. Defense counsel moved to strike for cause. So they both raised this issue. And the judge said, nope, I'm set. I'm not going to ask any more questions. And I did file a 16L letter with some striking similarity in both the question and in both Alice Ham.
And here's, again, we're not there. If the answer is no, and then there's a long pause, and the juror's looking and sort of thinking and says, it comes down to blah, blah, blah. Maybe the judge doesn't find that ambiguous. I mean, the first part of the question is there a racial component to it? The juror answers no. And then in thinking, potentially, the juror says, it really comes down to blah, blah, blah. There wouldn't be anything wrong with that, would it?
Yes, Your Honor. So all we can do is speculate in how the different ways in which this juror might have said these
I don't see how it matters. I mean, to me, it seems ambiguous even if he does a long pause. He doesn't say, you know, a propensity to crime depends on where a person lives, or if he means no, but African Americans who live in certain places do have a propensity to commit crime. That's what we don't know what it means. I'm not sure. I mean, I'm interested in your answer to this hypothesis, but I'm having a hard time understanding what intonation he could have used that would have cleared up the ambiguity. I don't know what he meant, of course.
Yeah, I agree with that. I think even if we speculate, we come up with different ways in which the juror might have said this. I think any way we can come up with, there's going to be ambiguity. And it's going to be problematic in even how we interpret it, even if it's a racial component, clearly problematic, even if it's just an economic component. If the juror thinks that people who live in an impoverished state are more likely to commit crimes, that's highly problematic too. So in any kind of way we can interpret this, the bottom line is the judge should have followed up. And it was pointed out to him by both counsel. And in Clark, the judge even did more. The judge did follow up. The judge said, well, just to go over the question in Clark, do you believe African Americans were more likely to commit crimes than other groups? Do you believe that because a person is African American, they would be more likely to commit a crime? Juror X answered that he believes, or he or they believed African Americans as a group were more likely to commit crimes because of their economic status than people of other racial or ethnic groups. The judge follows up, why could you be impartial? And the answer is because I think it would depend on the person's circumstances. So that raises both racial and economic issues. And the court there said, that's not enough. You need to ask more questions, because they reversed on that issue in that case. So I think it's on all fours with Clark, just as issue one's on all fours with Lahan. If there aren't any more questions, I'll rest on my brief for the remaining.
I have some questions.
You have four other arguments, and I'm sure we have questions about them.
On the quote-unquote, sleeping juror issue, there's no finding made that the judge believed that the juror was actually sleeping. In fact, the record could be that the juror wasn't sleeping because when they looked over, I think it was defense counsel that says, oh no, he has his eyes open. So where it's unclear whether the juror is sleeping or not, is there an obligation on the judge's part to bring a juror over and say, hey, were you just sleeping?
Yes, I think the language used in the case law is a reliable report. Here, the report came from the prosecutor.
Well, the reliable report in some of those other cases, the juror is actually snoring. Mm-hmm. I mean, it's pretty crystal clear in some of those other cases that the juror is actually sleeping. Mm-hmm. Here, you know, the juror could have just had his eyes, or I can't remember whether his or her, but the juror eyes were closed, maybe thinking, maybe it was just part of the argument or the opening statement, and then opens his eyes. So I guess I'm asking you, if a judge is given a report, not that the juror is sleeping, but that the juror has his eyes closed for X amount of seconds, X amount of minutes, whatever, is that the obligation that a judge has to do?
Yes, I think, so in this case where the prosecutor, again, asked for a sidebar to bring it up, pointed out they believe the person was sleeping, and then during the sidebar, there's a discussion of it, and at some point during the sidebar, the defense attorney says, oh, he's awake now.
He doesn't say now. If he'd said now, then this would be dramatically clearer.
Direct quote. I honestly do not remember the exact words that were used by defense, so I apologize for any misquotation. But so there certainly is enough there to, again, trigger this judge to look into this more. I think it seems that there's...
See, I'm trying to find the line here, counsel. As a former trial judge, jurors often close their eyes when witnesses are testifying, and it appears maybe they're just thinking. Mm-hmm. And I'm trying to find the line here as at what point does the judge have the obligation to inquire further? Here, you know, if the lawyer had said, hey, the juror had his eyes closed the entire opening statement, I think he was sleeping. Okay, that takes us more to the line, the whole opening statement. Here, I don't know how long.
I thought they said the whole opening statement.
I'm asking, you know what?
I don't remember.
I don't remember off the top of my head, but my recollection is it was during the whole opening statement. And as far as where we draw the line, I think if it's brought to the court's attention by both the prosecutor and the defense attorney, and the judge doesn't make a contrary finding on the record, say, no, he was, moving around even though his eyes were closed, that kind of thing, and he just says, oh, I'll just keep an eye on it, I think that's a dereliction of duty in that respect. I think he needed to inquire of the juror to make sure he's going to be awake and alert for the rest of the trial.
Let's assume it was the entire opening statement. I think that might be accurate. Does it make a difference that it's the opening statement, which is not evidence? Because some of the cases talk about, I can't remember the language, but it's kind of like an important part of the case. Mm-hmm. Is an opening statement that important?
Yeah, it is, Your Honor. It's an essential part of the trial. It's where the Commonwealth lays out what they think the evidence is going to be, and the defense's opening statement is an opportunity for them, to lay out what they think the evidence is going to be. So it's an important, tone setter for the trial. It's not like
from that perspective, then, counsel, what is not an essential part of the case? Certainly, witness testimony is pretty essential. Closing argument is probably pretty essential. Yep. So when they use that language, which they do use, what does that mean?
So I think anytime a juror is supposed to be paying attention, that's an important part of the trial. So it's one thing if it was a long sidebar and maybe somebody, lost their attention and maybe does. But I think anytime where, a juror is supposed to be paying attention. Which of course they should be when the prosecutor is addressing them in opening. If any other questions on that, I'd move on to my final issue, improper closing. The prosecutor created a reversible error in her closing argument when she told the jury that defense counsel's job was to distract the jury. She characterized defense counsel's closing argument as a conspiracy theory, and she relied on facts not in evidence to explain away the absence of a police officer involved in the arrest of the defendant. I know it's, I'm not arguing that it's not okay for a prosecutor to comment on the defendant's case, but in this case it went too far. It crossed the line into cheap shots and denigrating her role and her specific decisions in the trial. And it's our position that that's also reversible error.
Can I ask you a question that goes beyond the arguments you make? If the Hertz documents hadn't been admitted, mightn't that have altered the outcome of the assault charges?
So the Commonwealth's position is that the admission of the Hertz records only impacted the gun charge.
I don't think they spell that out. I think they just say, so the gun charges are gone.
Yeah.
But you didn't file a reply brief, I don't think.
Well, I filed a 16L letter, I didn't.
Yes, I'm aware of that. It cites one case which frankly was decided in 2006, and that's not really what a 16L letter is for, but whatever, we have it. But you didn't file a reply brief saying what this confession of error implied. You're not arguing that if the Hertz documents hadn't been there, that the assault case might have looked very different to the jury.
No. The admission of the Hertz records, if they had not been out, no, I don't think they would have an impact on the assault charge.
Okay.
Counsel, your issue regarding the closing argument says that the prosecutor said it distracted you from the truth. That's not quite what the prosecutor says. Again, it's a she, sorry. She basically makes the red herring argument, which we've seen in thousands of cases where counsel for the prosecution makes the argument that defense counsel is putting issues in the case that aren't important, and they distract you. What's different about this argument than all of those other cases that say that's proper argument?
So I think it has to be viewed in context of all her statements. Conspiracy theory, just the language she used, which I've already gone over.
Which was unobjected to, correct?
True. So the conspiracy theory, the comments about the defendant's, role in the jury, that was objected to.
Okay, thank you.
There are no further questions?
I see none. Thank you very much. Very good argument.
Thank you.
We will hear next from Attorney Baker.
Good morning. May it please the Court, Assistant District Attorney Lee Baker for the Commonwealth. I would like to begin by addressing directly Commonwealth versus Clark, because I, of course, did not address that in my brief. It's an interesting case, and I think it actually brings into focus the issue here in a really telling way. We have to look at the facts of each of these cases. Now, with Clark, the juror was asked whether she believed African Americans as a group were more likely to commit crimes, and she responded that yes, they were, but that was because of economic circumstances. So the question is, are African Americans more likely to commit crimes? The answer is yes, then with an explanation for why the juror thought that was the case. Here what we have is the juror is asked a slightly different question, and the wording is, I think, somewhat significant. The juror is asked if she believes that African Americans are more likely per capita to commit crimes.
Same question.
I'll get to why I think it's slightly different.
Okay.
And she responds, no. And then she gives an explanation of, it depends on where you live, which I think we're all reading as, it depends on your economic circumstances. The reason why I think that the framing of the question is somewhat significant is that when it's framed as, do you believe that African Americans are more likely to commit crimes, then the plain meaning of the question is, do you think there's an essential characteristic about African Americans that make them predisposed to commit crimes? When it's framed as per capita, now it's already asking the person to think of this in terms of statistics. And I would suggest that's why you got an unequivocal no followed by sort of a consideration of the
You think this question was asked to get at statistics, not at racial bias?
No, I don't think that's the case. I do think that the question was asked to get at racial bias. I do think that the juror answered unequivocally no, and then the juror gave a further explanation that adds some ambiguity to that initial unequivocal no. And I'm suggesting that part of what invited that juror to sort of to editorialize was the way that it was framed, perhaps.
Let's assume you're correct. You just said created some ambiguity.
Right.
And the lawyers that were present had some ambiguity. Isn't the purpose of voir dire to flush out questions and what a juror might mean by an answer?
Absolutely.
So by the judge not asking a follow-up question, specifically requested by the trial, isn't that error?
Well, what I would say is no, it's not error. I would concede that it's not the best possible practice. But as you yourself pointed out, we're looking at a cold record. And so we don't really know how that person said what they said. And certainly the prosecutor brought it up, and I think that the total record shows that this was a very careful prosecutor who is very concerned about potential appellate issues. I don't think that the fact that the attorneys brought it up goes that far to how ambiguous it was in the moment. It certainly is some evidence to that. Certainly it could have been read that way. And the ideal practice...
That's the ambiguity, and it looks like Clark says. Follow up.
Sure, but as the court has admitted, if we could hear it, we might all have a very different take on it.
The court hasn't admitted anything, but go ahead.
Well, I came in conceding a bunch, but anyway, fair enough. So what I would say is that, yes, in an ideal world, there would have been further inquiry. What I am suggesting is this is a busy trial court. The trial judge is looking at this situation. To his ears, in his discretion, that was unambiguous and clear, and he wanted to move along.
I don't think he has discretion to decide what's unambiguous if it's ambiguous.
Well, right. But again, what makes this ambiguous is we're reading a cold record. And so I would suggest there has to be some deference to a trial judge's discretion in those circumstances. And that's really where I come down on the issue, is that yes, there was some degree of ambiguity here, but not so much that it was an abuse of discretion.
Well, it's about racial bias. It's a pretty important question.
That's true. It is very important. It's very important. But again, when it was, in terms of the essential characteristic, it was an unequivocal no. And we only see some ambiguity because the juror then chose to talk about economic situations. But that's different than Clark, where it was all of a piece. Yes, African Americans are more likely to make crimes, and then an explanation that the juror gave for voicing that kind of bias.
What about, let's put, and I don't know how we do it, but for a second, let's put apart the racial component.
Sure.
What about the economic inequality in the answer? Doesn't that raise a concern for a trial judge and the lawyers that, wait, what do you mean? So if a person is poor, they commit more crimes? So are you automatically saying if you find out that this defendant is in poverty, they commit more crime? I know logically that might be true.
Right.
But if a juror expresses that,
yes,
don't you have an obligation to flush that out a little bit more?
Well, I would say no. I mean, that's not an essential characteristic. And it's not, look, it is clearly a vicious form of bias to assume that because a person is of a certain race, that they're more likely to commit a crime. It is a simple statement of fact. We can go back to Victor Hugo, that poverty makes someone more likely to commit a crime. So I don't think
I
that
remember
that's a
taking an
bias.
oath to do equal justice to rich and poor alike.
Absolutely, absolutely. And what I'm saying is we all come into the courtroom with certain biases. I mean, cognitive scientists can show you a range of cognitive biases. And if we wanted to be perfect epistemologists and have trials in an inquisitorial system in which there was no bias of any kind, that would be a completely different system than what we have.
But when a judge learns about somebody's perhaps inherent bias,
yes,
isn't it the obligation of the trial judge to ask a follow-up to say, will you be able to put that feeling aside and judge this case solely on the facts and evidence?
I would suggest that would be far more pertinent if the charges were different. Because what we have a case here is an individual is said to have possessed a firearm in a rented automobile. This isn't, somebody stealing a loaf of bread from the supermarket.
I don't think that that's what that answer means.
Yeah.
When someone says it depends on where you live, I don't think they're saying if you live in a poor neighborhood, you're more likely to steal bread for your baby.
But don't we acknowledge that there are high crime areas in which crimes occur with more regularity? I mean,
We certainly might acknowledge that, but then again, we ask jurors to put those personal feelings aside.
Sure.
And maybe if the judge had followed that up, we would have gotten that answer, and the juror could have said, oh, that's my personal thing. If I don't hear any evidence about that, yeah, I can put it aside. But we don't have any follow-up questions.
Right, but we also don't have anything that really makes that a live issue in this case, I would suggest. Where it's very different with the race issue. The race issue is very much a live issue.
Let's move on to the so-called sleeping juror.
Yes.
What is your argument as to why the judge shouldn't have inquired on that?
Sure. So going back to just the facts here, right? So the prosecutor does her opening, and then she goes sidebar and she says to the judge that this one juror had his eyes closed the whole time, doesn't claim he was asleep. Judge says he's going to keep an eye on that. All right, so the judge acknowledges that the issue's been raised, and he's going to pay attention to that juror. And there's nothing in the record that suggests anything beyond that. Now, and so we don't know that there was any other behavior on the side of the juror that would raise that issue. I think we can grant the judge a presumption that he did what he said he was going to do and watch that juror. And I do think that the stage in the proceedings is very important, because what is the purpose of opening arguments? Now,
It's to frame all of the evidence you're going to hear.
Absolutely.
So that you can understand the case of the person making the opening argument. It seems important to me.
Absolutely, absolutely. And having prosecuted cases and defended cases, I know it can be very important. It depends on how factually complex the case is, for sure. This was not a complicated case. There wasn't complicated evidence. The other thing that I would stress beyond, we don't know that this juror wasn't paying attention, is that the portion of the trial that is at issue is the prosecutor's opening statement. So that means that even if that juror was checked out for the prosecutor's opening statement and then an alert for the defendants, then they did get a preview of the evidence, and they got that evidence previewed with a slant favorable to the defendant.
Even if we find error, you're saying it's harmless?
Exactly. I don't think that there is error, but if there is error, what happened was the prosecutor lost the opportunity to frame the evidence in a way beneficial to her. And so for that reason, I would say...
I think the defendant is entitled to awake jurors.
Absolutely. And there's no evidence here that that juror...
So Villalobos says if there's a serious possibility that a juror was asleep.
Yeah.
Now, we use phrases like resting your eyes. I like to think I've never done that on the bench. I don't even know what that is, resting your eyes. But okay, for a few seconds, for whatever, you lean back, whatever. Having your eyes shut for the entire opening seems like a serious possibility of sleep. To me.
You know, we're sort of trading intuitions here, because I would say the exact opposite, that I often close my eyes when I'm listening to an argument so that I can concentrate on it. That may say something about my cognitive abilities more than anything, but...
Well, I'm sure you don't want me to close my eyes while you're making this argument, but all right.
Well, maybe now I do.
Maybe so.
If there are no further questions, I'd rest.
I'd like to ask about the job of a defense counsel. Is it to distract people?
No.
That's what the prosecutor said.
Right. Yeah. You know, that was not nice. It shouldn't have been said. I don't think it rises to the level of a substantial risk.
That was not objected to? I don't remember which one was objected to.
My recollection was that neither was, and I may be
It was
wrong.
an objection at the end of the closing,
Okay.
and the defense
Yeah.
lawyer makes a few different arguments, and I think he specifically uses the red herring as something he objected to.
Right. And you know, and with regard to that, I would point out that conspiracy theory, red herring, these were not used in broad sort of ways to impugn the attorney. They were tied into specific arguments. This was a red herring. This was distracting. Not, oh, forget that attorney and their conspiracy theories. They're just here to distract you. They were pointing to actual things in the closing argument that were, in the prosecutor's opinion, distracting from the central issues.
Well, that's why I asked you not about those, but about this phrase. It's her way of distracting you.
Yeah.
That's her job as a defense attorney.
Right, yeah.
Right? That seems bad to me.
Yes, it is. I will admit that for sure. Shouldn't have been said.
I see no further questions. Thank you very much for another very good argument. The case is submitted. We will hear our third case. I will just let the court officer and counsel know that we will take our traditional mid-morning break after the third case. The next case is number 25-144, Commonwealth versus Lopes. And we will hear first from Attorney Hansen.
Thank you, Your Honor. If it pleases the Court, Arne Hansen for the Commonwealth of Massachusetts, representing the Plymouth County DA's office. My argument today is twofold. The first of which is that the Superior Court abused its discretion in refusing to accept the findings of the appeals court when this case was before this court last year on the exact same issue. The second one is, even after the defendant was given an opportunity to backfill his argument based on the appellate court decision, given an evidentiary hearing to supplement the record, he still hadn't met his burden to show that he had special circumstances, and it would have been rational for him to reject the plea.
Did the Commonwealth object to the judge having that hearing after the appeals court decision?
I don't believe I did.
So why isn't it waived? We often use waiver for defendants. I'm curious as to why the Commonwealth didn't waive this argument by not objecting.
With respect to that issue, I handled the second evidentiary hearing as well. My perspective going into it was the appeals court had ruled on the legal issues in this case, that he didn't have special circumstances, and that it wasn't rational for him to reject the plea deal.
Why did the panel say in its decision, we leave the question whether to hold an evidentiary hearing to the sound discretion of the motion judge? What was going on with that?
That I don't really understand. So the defendant didn't request an evidentiary hearing when this was before the court in the first motion for new trial. My argument before this court the first time it went before the appeals court is, one, Attorney Krowski, who was the plea counsel, wrote an affidavit. I said there was ambiguity within that affidavit suggesting it wasn't clear what advice he did give and did not give, because his affidavit, from my perspective, seemed to contradict itself. the appeals court panel that handled the case the first time rejected that argument and said, no, he was ineffective. So that was the only request for an evidentiary hearing. I had said that the judge abused his discretion by not fleshing out that issue. The court disagreed with me. From that point on, nobody else had requested an evidentiary hearing, so I don't understand why they remanded it.
It did, for whatever reason, right? And, I think you raised some really good points about how we are kind of locked into what the prior panel said on this case, but when they do say, the judge has discretion on remand to have an evidentiary hearing, it's hard to say, wow, the judge really ignored the panel decision, right? I mean, that's my problem with one of your.
So, and I think there's a distinction here. They didn't say there isn't enough in the record for us to address whether or not there are special circumstances. We need to develop this record further. They said, given everything that we have about this case, given everything that we know about the defendant's situation, he doesn't have special circumstances. And I think that's an important distinction. If they had said there's not enough for us to make this decision, we remand it to develop this record, certainly the judge, the Superior Court judge had discretion to have an evidentiary hearing to develop that further. But here the court was clear. We know enough about this situation. It would not have been rational for him to reject the plea because he didn't have special circumstances at the time. And that was very clear in the court's decision. And that was ultimately the issue that
So tell me again, what was the evidentiary hearing on remand supposed to flesh out?
I don't know. The defendant...
Well, okay.
The
I mean, if you
defendant
said to
requested-
me, no, that was just this tiny question that might have made a difference, but it wasn't special circumstances or what supported that claim, I
The appeals court decision isn't clear.
We're very, we are bound by, in this case, the broad statements, whatever it was, this and this and this aren't enough. I don't remember. It was like having a job, having relatives here and something else.
Yes.
But then there's a remand. There's talk about additional responsibilities, particular responsibilities this person had with respect to their family. There's, all the additional evidence that the judge finding the witness credible relies on. Now, we can't undo the credibility finding, right, because we didn't hear the witness. I don't know. They remanded it and said you can hold an evidentiary hearing, and the judge did. And then that's the basis for in the decision, that's these additional things are the basis for the outcome.
Right. It's certainly an unusual decision where they say we remand it to further proceedings consistent with the findings in our decision, which was the legal issues have been resolved. And then they give them the option for having a hearing that the Commonwealth requested on a legal issue that had been resolved, which doesn't make any sense to me.
Did you move for reconsideration here?
So I don't know how much good that would have done me, given that the appeals court had already decided the legal issue, and I don't really think that Judge Glennie would have really endorsed that or even looked at it.
No, I'm saying here.
Oh.
You've made a mistake, appeals court. We love your whole decision, but we don't think there's a reason for a remand. We think that was erroneously included or is inconsistent with the rest of the opinion.
I had not considered that.
No.
It's the motion judge has to follow the panel decision, and I'm just trying to put myself in the mind of this motion judge. When you get a decision saying you have discretion to have an evidentiary hearing, the defendant wants an evidentiary hearing, the finding is there isn't enough evidence on the current record on special circumstance. Could the judge, if it said, no, you don't get a hearing, that's it, I'm just going to rule again on the record? I mean, it seems almost like the judge was required to provide an evidentiary hearing under those circumstances.
I don't read it that way. The court gave him the option to, and then the defendant requested it. There was no order to have an evidentiary hearing to flesh out the record because...
The judge could have said, well, I know I have discretion to give you a hearing, but I'm not going to give you a hearing, and we're just going to go on the papers as they exist.
Correct. I was a little bit perplexed when there was an evidentiary hearing because it was my position, and I think it was clear from the decision, that the legal issues at issue here had been resolved.
Can I go back to my question? Why isn't it waived? You didn't object to the evidentiary hearing when it took place. So why, I mean, you're arguing in your brief that the judge shouldn't have had an evidentiary hearing. Why isn't it waived? You didn't argue it below. You didn't even give the judge the opportunity. That's waiver.
That's fair, but it's because the court had ruled on the legal issues. So irrespective of what the evidentiary hearing brought out, the legal issues had been resolved.
But you don't need an evidentiary hearing after the legal issues have been resolved. That's the end of the case.
Right, which is, I don't understand what was the logic and motivation behind the appeals court's decision in writing that at the end. It seems like it was a throw-in for an issue that didn't exist.
So your argument has to be that the judge abused his discretion for holding the evidentiary hearing because that's what the appeals court said the judge should do. And you didn't object and say, you shouldn't do this, judge, because blah, blah, blah. You didn't give him that opportunity. You just went forward.
I did, on the record, state that while we're having the evidentiary hearing, at the conclusion of the hearing, I asked him to respect the appeals court's decision because I thought this matter had been resolved. So that's not specifically I object, but I did point out there was absolutely no point in having an evidentiary hearing because the legal issues had been resolved. Now, with respect to what happened subsequently, the defendant had an opportunity to supplement the record and raised a bunch of different points that he didn't choose to include in his 2022 affidavit. Defendant testified that he gave one set of testimony on direct examination, and then when cross-examined, the facts were flushed out. He tried to create a factual setting where everyone else was dependent on him, and on cross-examination, I think it became very clear that he was dependent on the people that he said were dependent on him. With respect to his mother, it became very clear that he was 19 and he lived with his mother, who was gainfully employed and whose name was on the lease. His name wasn't on the lease. He lived with her. He said he helped pay with bills, but she paid the rent. She was certainly the matriarch of that family and didn't appear to be financially dependent on her son. The defendant then raised issues with his grandmother, and then on cross-examination it becomes clear the grandmother lived in a separate apartment.
What were the judge's findings on these, what you're, I think, alleging are inconsistencies?
I don't think he addressed them. I think he credited the defendant's half of the story without considering what was brought out on cross-examination.
Isn't that a credibility determination?
That's fair, and I'm not contesting that the defendant testified not credibly. I'm suggesting he testified credibly to everything, but the factual circumstances don't warrant special circumstances. So I think it's very clear that in the Rodriguez case in 2022, the court said having family members here and having family members with legal status in the United States is not enough. They have to be dependent on you. Mm-hmm. And that's what the defendant tried to testify to at the evidentiary hearing. But that didn't come out because it became very clear that he was dependent on everyone else. I'm sorry, Justice Rubin.
Are you saying that the findings of fact by the judge are clearly erroneous?
I'm saying that the findings of fact, the facts that came out at the evidentiary hearing don't support that there are special circumstances because, not challenging the credibility, but everything that he testified to does not establish that these individuals in his family were dependent on him. It actually suggests the opposite. His grandmother lived in her own apartment. She did not live with him. She was not dependent on him for care. He drove her to appointments and drove her to the grocery store. That doesn't establish dependence. In fact, she was his sponsor. And then he tried to establish that he was raising his cousin's children after his cousin was killed, but then on cross-examination, that doesn't come out either. On cross-examination, it becomes clear that the cousin's children would live with their mother, and he would see them when they're at the grandmother's house. Those kids would go to the grandmother's house when the cousin needed help taking care of the kids, which again suggests, one, he's not taking care of the kids, the grandmother is, and two, if the grandmother can take care of these kids in her own home, she's not dependent on him either. She's certainly living her own life.
I'm not saying that this would have been my finding, but if the defendant drives the grandmother to all appointments, why can't a judge make a finding that that means the grandmother's dependent on the defendant?
That's like a taxi service. That can be
Okay.
supplemented by a
Well,
taxi
people
service.
don't have money for taxi a lot of the time, right?
Right, but she lived in her own apartment and was taking care of the cousin's kids as well. It doesn't appear that she needed help from anyone.
Does the SJC or our case ever define what dependent means? Because you seem to have a definition of dependent that's different than the judge's.
Yes, it's financially dependent.
Like for
And they are also dependent for care.
Providing more than half of their support, like for federal tax purposes, dependent?
I think the examples that are given is financial dependence. So certainly what the court has consistently ruled is if you have children, they're obviously dependent on you because that's what the expectation is. You raise your children. You educate them, you feed them, you clothe them, and you try to instill good moral values in them. The other side of it is the inverse is the Cano case where that person has a very low IQ and is dependent on day-to-day tasks because they have the emotional and intellectual intelligence of a 6 to 13-year-old, depending on the category. So that's someone that needs help with every task because, unfortunately, their IQ is in the bottom, they're in the second percentile.
So we have to find, because this is an abuse of discretion standard, that the judge made a clear error of judgment in weighing the factors and determining the special circumstances factor. Is that right? Is that
Yes.
what essentially your second part of your wrong is clear error of judgment,
Yes.
right? Which is a pretty high prong for appellate review, right?
Yes, but so my position is that his circumstances didn't change between the first time this court ruled that he didn't have special circumstances and the second time because he wasn't able to establish that anyone was dependent on him. And that was what the original appeals court decision hinged on. You have to demonstrate dependency, which is why he went back and tried to establish that, and I don't believe he did.
Can I just ask a quick question about the substantial ground of defense prong? The information in the defendant's brief on appeal, was that presented to the judge?
No, so that is an issue. So there's been a change of counsel, and appellate counsel now is not counsel who handled the prior proceeding. So where that wasn't before the Superior Court and it's being raised on the first time on appeal, it's not properly before this court.
I thought we could affirm on any ground shown in the record. We do that for the Commonwealth a lot.
I think what we're evaluating here is whether there was an abuse of discretion based on what Judge Glennie had in front of him. The arguments raised on appeal for the first time here were not in front of Judge Glennie.
But can't we affirm on any ground evident in the record?
Yes, that's also fair. For my last 5 seconds, I'd like to distinguish the cases that the defendant relies upon. One is the Sylvan case. Sylvan is clearly distinguished because he had a child that was dependent on him at the time of the plea. Here, that's not the case. And then there's two unpublished cases, Young Kim as well as Swain.
You don't have to rush. You can tell us what they are.
So those two cases are unpublished cases from 2020. What distinguishes those cases is they come before Rodriguez. So in those two cases, the court held that having family ties, a job, and residency here was enough. Rodriguez clearly abrogates those cases because
and those are not published anyway, right? Those aren't.
Yes.
Yeah.
So that it's a double argument. One, they're not binding, and two, they're abrogated by Rodriguez, which says you need to establish dependency. If there are no further questions, I rest.
I see no further questions. Thank you for an excellent argument. We will hear next from, because I'm getting confused here, Attorney Noonan.
Good afternoon, Justices. Justice D'Angelo, Justice Rubin, Justice Toone. My name is Patrick Noonan. I represent Mr. Lopes. I'd like to address all three questions that were addressed by the panel. First being what the purpose of the remand was. And my understanding was one of the purposes was to establish what the defendant's special circumstances were at the time of the plea, because the appeals court found that the judge erred in considering a factor that wasn't present at the time of the plea, was just the fact that he had a child. So when the hearing started, defense counsel came out and kind of laid the groundwork for what the hearing would be and said, Judge, you know, we're here today because we're going to have a hearing to determine what the defendant's special circumstances were at the time of the plea. So that's where the defendant came in and testified. As Justice D'Angelo noted, the Commonwealth didn't object to that, and that's the record that we have. So the defendant testified as to the special circumstances at the time of the plea. Judge credited that testimony. The second part of it, I think Justice D'Angelo had said about dependency. What is dependency, and what were the judge's findings, you asked, on dependency? Justice Glenny, in his findings, stated that the defendant was very close to his family and, quote, helps take care of his immediate family, and then later on says, took care of the immediate family members. So I don't believe that the law requires that there be this definition of dependency as like a strict financial dependency. The defendant did go into detail about how he does help out his family. He had his mother, who was on the lease, but testified that he did pay some of the utility bills. And by the way, he was working 3 to 4 jobs, almost 2 jobs at a time. So helping the mother with the bills. He also had an elderly grandmother who was in her 80s with blood clots and diabetes. She couldn't drive a car, so he had testified he drove her everywhere she needed to go. Medical appointments, even up into Boston, he was taking her to. And Brockton, he'd get the groceries and food for her. Thirdly, he had an uncle who had a leg amputated due to diabetes. He also helped drive for him as well. Then he had a cousin who was murdered, who had 2 kids, which he also helped take to the bus stops, take him to McDonald's and things like that. So not strict financial dependency, but a lot of people depended on him to get, where they needed to go. And if hypothetically we didn't have the defendant, then it would be putting the grandmother, who's elderly and in her 80s and can't drive, in a very bad predicament. And on the motion to suppress argument, counsel was right. I came in for purposes of this appeal, and one of the things that the appeals court said for the purpose of remand was that the judge failed to examine the totality of circumstances, which were 1, whether there was a substantial ground for defense, 2, whether there could have been a more favorable plea deal, and 3, special circumstances. So as new appellate counsel, I came in and looked at the totality of circumstances. And in terms of a defense, it's a drug case. The first thing I do is I look at the search warrant. And I think that the Wade case really, really supports the fact that he had a strong motion to suppress on the search of the Nissan. Now, I don't have to prove that he would have been successful on the motion to suppress, just that it had some substantial bearing on the case that would have led him to want to contest that.
I think it's great work as appellate counsel, but my question is, was this fairly presented in the record below, right? I mean, that's the question, right? Obviously, it wasn't presented to the motion judge. You never heard these arguments. So you're doing this great work, to us. We're not supposed to be like the court of first impression on an issue like this. And I guess, is this really an issue that we could sort of say, well, it's an alternative ground for affirmance, or is there something else? Because you're really digging into the record here and looking at the search. I mean, it seems like you're going a little bit farther than.
Yeah, I mean, unfortunately, everyone just conceded up and down the line. He had no defense. But I think that when the court on remand is saying, let's look at the totality of circumstances, a substantial ground for defense is one of the circumstances that the court can consider. And I think this court can look at because we're looking at also, not only is there abuse of discretion, but we're looking at significant or substantial errors of law, and we're applying the totality of circumstances. Substantial ground for defense is one of those, and the search warrant's in the record. It's a case where the justices here can just look at the search warrant. It's not evidentiary hearing. The record's before you. And I do cite on page 21 of my brief where it was a case where it was rational for the defendant to reject a plea because on appeal he established that he had a substantial ground for defense on a motion to suppress. So I would ask the justices to consider hearing that particular issue. But
I have to say, this is, for lots of reasons, including double jeopardy, this is an unusual case where the Commonwealth is the appellant. But in many cases where they're the appellee, they raise an argument and tell us that we can affirm on any ground visible in the record. I don't remember what the exact phrase is, but supported by the record. When I first heard that, I thought, surely it's limited to things that were raised below. But that, I have looked and looked in those cases, and that seems not to be the case.
And I concede it wasn't raised anywhere below.
No, I get that. I get that.
Can we go back to the dependent argument?
Yes.
Which is, to me, can we overturn the judge's finding that the family was dependent on the defendant by saying that that dependency is irrational, that he wouldn't have accepted the plea?
Well, I think...
Well,
I think that...
Objective, getting mixed in.
The judge credited the defendant's testimony, and he credited him up and down the line. He said that this guy had a dream come true in this country, he appreciated being in this country, and he credited his testimony about taking care of his family. I don't think that that this court can overrule the judge's finding by saying, like, here's a strict definition of dependency. I guess we can go to, like, probate and family law and say what dependency is, and that's the law.
But in other circumstances on these types of cases where a judge finds it credible that if the defendant had known X, he would have pled, or he would not have pled, I'm sorry, he would not have pled. Our court has said, well, we have to look at whether that's a rational decision.
Right.
And if we find it would, even if the judge credited that, it's irrational, then we're supposed to,
so
why isn't this the same circumstance?
So I would say, in terms of it being rational, the defendant checks a lot of the boxes, and two of the cases that I cite, Kim on page 47 and Saw on page 45, those people didn't establish any dependency. They didn't have any children that were dependent upon them whatsoever. In terms of looking at whether it was rational, look at all the factors. The defendant checks a lot of the boxes, although maybe not legal dependency, the people he took care of. In the original decision, the court said, well, he had employment, and they said auto body shop. On remand at the time of the plea, he had 4 jobs. The only person that he had in Cape Verde was an elderly grandfather, so he had no ties to Cape Verde. Let's say he was deported, and he goes back to Cape Verde. He has nothing. He has an elderly grandfather, and he testified that when he was growing up, he was poor. His grandfather was the only person there that was making 50 cents to $1 a day. He had no shoes. He would go days without eating. So it would have been rational for him to take a plea, to go to trial, because he's got nothing to go back to in Cape Verde. And the other thing
isn't that almost always the circumstance in all of these cases? That's not what we look to.
Not necessarily, because we had somebody that was going back to Italy, and Italy wasn't, an impoverished third world type of country.
Oh, but we've had plenty of cases where they're war-torn countries,
sure,
and we've said that you look at it at the time he pled, is it a rational decision that he would have risked going to trial versus, in this situation, deportation? And
well, I'd say that he did have those dire circumstances to go back to.
Well, De Jesus says, and this is what's cited by I'm just looking at it because I was looking at the judge's decision. It says, for non-citizen defendant, preserving his right to remain in the United States may be more important to him than any jail sentence. Thus, a determination whether it would be rational for a defendant to reject a plea offer must take into account the particular circumstances informing the defendant's desire to remain in the United States. So I don't think that I don't think it's automatically irrational I think this says it's not automatically irrational to go to trial in a case where you have no substantial ground of defense rather than simply accept deportation.
I mean, you do have the cases that stand for the principle that, you can have like the most minuscule chance of winning a trial. You'd still take that risk to go to trial with the minuscule chance of winning and risk it. And there's also cases that say if you have no substantial ground for the defense, you're going to risk it. But getting back to the circumstances existing at the time of the plea, the one thing that was omitted in the original appeals court decision that was fleshed out at the evidentiary hearing was that they didn't mention his education at all. And one of the things he had testified to back in Cape Verde was that he couldn't really have an education because they couldn't afford to transport him to the school. And then when he came to the States, he went to public schools and graduated from Brockton High with mostly Bs. And the judge also looked into what opportunities he had available here, which he took advantage of. He took advantage of those things. He went to school, and he worked, and he wanted to become an airplane mechanic. And he was working 3 jobs to pay for a car so that he can commute to go to the mechanic school. So those were things that this judge considered. And he considered his sincerity in wanting to remain in this country and found that it would be rational for this individual to risk it and go to trial. If there are no further questions, I would rest on my brief.
Very good. Another excellent argument. Thank you.
Thank you, Your Honor.
I see no further questions. So the case is submitted. We will take our traditional 10 to 15-minute mid-morning break, and we'll hear the 2 remaining cases when we return.
Court is now in session. Please be seated.
Welcome again. Our next matter is an impounded case, so I remind the attorneys not to use the names of the parties. We'll go with things like older child, younger child, mother, and so on. It is Department of Children and Families versus Mother, and we will hear first from Attorney O'Brien.
Good morning, Your Honors. May it please the Court. Tamika O'Brien on behalf of, excuse me, appellant Mother. This case, Your Honors, turns on whether or not the juvenile court applied the correct legal standards when it terminated my client's parental rights. Respectfully, it did not. The judgment must be vacated because the findings relied on remote history and speculation. The court improperly assessed Mother's fitness collectively rather than child by child, and the court approved a permanency plan that was generic and legally insufficient. Termination requires proof of current unfitness by clear and convincing evidence. And in this case, Mother argues that that was not what happened here. 67% of the findings of fact out of 72 findings were about Mother's past mental health issues, her previous hospitalizations, the children's bond to each other and to their mother, and their current placements. Your Honor, Your Honors, by 2022 to 2023, Mother had stable housing. She was compliant with medication. She had taken parenting classes, was enrolled in a domestic violence program, had completed a psychological evaluation. And while history is relevant, it can't be a substitute for evidence of current fitness.
Well, I think from the first moment of the judge's opinion, it is quite clear that the very primary issue here is these episodes of dramatic decompensation where the mother is psychiatrically hospitalized after an episode of frightening and dangerous behavior. And that doesn't, I think that's not, although we are looking forward very much to hearing from the oldest child's attorney about this, it doesn't seem child-specific. It seems like an ongoing problem, and it has happened repeatedly, and well, I don't know if I want to say involuntarily, frequently Mother stops taking whatever medication she's on. I don't know why, in what way it's an error for the judge to conclude that'll keep happening. And some of the hospitalizations apparently, or at least one of them I don't remember, occurred while she was taking the medication. And it's 8 hospitalizations in 12 years, and one of these children was 10 at the time, I think, of the oldest one was 10. And how can it be an error for the judge to say this pattern has gone on, while DCF was involved, on and on and on, it is not going to stop, and I don't want the children, or the children shouldn't have to live through that.
Sure. And those hospitalizations are not to be ignored. They are certainly concerning. However, past crises raise concerns, but it's not evidence of current unfitness. And I was looking through the trial transcript today before, and just going back through to see if I had missed something about whether or not Mother had decomposed or been hospitalized or had any issues in the year preceding the trial. And I didn't see anything, but what I did see was on page 191, DCF was asked, and I can read it directly or I can just summarize it, but basically your DCF's main concern is Mother's mental health. Correct. Is there any proof that Mother is not on her medication? No. She's had the same therapist since 2021. Does that therapist have any concerns about Mother's mental health? And respectfully, she'd been on a full year of stability. And
Did the current therapist say that he or she had no concern for the mental health?
the therapist didn't. The social worker said that she had spoken with the therapist, and the therapist didn't have concerns about mother's current mental health.
Okay.
There was
the
no-
mother's been diagnosed with some serious psychiatric
There
problems,
is a
particularly
chronic
bipolar
illness.
disorder.
There is no question that mother has a chronic illness, which had been stable for a year, and that coupled with the other, the progress she had made. She had housing, she had job, she was
But are
taking
you
her medication.
saying that she's currently fit because she's not going through one of these episodes? And but then if she goes through the episode, she'll be unfit. But then when she gets out of the hospital, if they've been successful, she'll be fit again and then unfit? Is that what you're saying when you say she's currently fit?
No, I'm not saying that, but the proof that DCF has to show is current fitness, not what happened in the past and what may happen. Yes, some of that is, the speculation or, the possibility of that happening is certainly relevant to some extent, but the trial judge cannot and should not have used mother's past mental health concerns against her in this way. She speculated way too much in this case.
But counsel,
Sure.
sadly, in a history of somebody's mental illness, they often take medication for a while, then for many different reasons, they stop taking their medication, and they go back into the throngs of mental illness.
Sure.
That happened, at least from the record, 8 times. And I guess to Justice Rubin's question, at what point do you say, well, it was 1 month she's been on her medication and she's doing great. It's 2 months, she's doing great. Mm-hmm. We can't have a firm line. So what does currentness mean in the context of the history of someone like this? I mean, I think it was, and again, please don't hold me, I'm going by memory. I think it was August of 2022, she's hospitalized. Again, presumably because she had stopped taking her medication. This trial was approximately 1 year later. So yeah, I'll give you that for 1 year she was doing great, but that had happened before for periods of time. In fact, I think the longest one was 18 months she had not been hospitalized, but then she was hospitalized again. So how do we deal with something like that? Sadly.
This is tricky, and I was looking at Bruce, and there it was 4 years, and here it's a year, and there is no set timeline. But a year coupled with the progress she was making, the judge herself noted that she was on her medication. Again, it was currently at that time, she was doing well. And if the court did not feel that mother had stability long enough to return the children to her, she had other less restrictive options other than termination. There was guardianship,
Did you ask for guardianship below?
Did I?
Or whoever the lawyer was, not you personally, whoever was the lawyer for the mother. Did she ask that guardianship be the alternative?
So the trial record, the transcript shows that one of the children had been placed with in a kinship placement.
The older one.
Correct, the older one, and the 9-year-old. And that at the time that the social worker spoke with her, and she was unclear as to the timing, but at the time that she spoke with her about adoption, the kinship placement was not interested in adoption. She had not had that conversation about guardianship. But that doesn't mean that the trial judge had to terminate rights to give these children stability.
Did you
and permanency.
ask the judge to order guardianship? Or did mother ask the
I'm
judge?
not entirely sure if mother asked.
Okay.
From the record, it does not appear that mother asked for guardianship, but it also doesn't appear that guardianship was explored by the department. And again, in this case, yes, I hear what you're saying, 100%. It is very concerning when a parent or anyone has 8 hospitalizations, but given that DCF had no viable adoption plan, these children were not, adoption wasn't on the horizon anytime soon, the court could have said, all right, look, we know that this case is going on. Mother seems to be doing, she's had a year of stability coupled with her progress, coupled with all these other things that she has done. She's done what DC has asked her to do. So at this time, termination may not be in the best interest of these children. Maybe something else would. She did not have to terminate the parents' mother's rights, excuse me, Your Honor.
What about, there's one finding
Sure.
that the mother's energy, quote, energy is consumed with trying to manage her own needs and mental health, and she remains unable to understand her children's current needs. So that finding seems to almost put aside the mental health issues, which admirably she's working on, but because she's working on them so feverishly, she's not tending to her children's needs.
I don't necessarily agree with that, and I see my time's quickly expiring, but I wanted to answer this.
Continue to answer.
Yes, she did spend a lot of time working on her mental health, which is what DCF had wanted her to do. However, she did acknowledge that she had made some mistakes. Her children had witnessed some of these things, and that she was advocating for mentors for her children and services for her children. And so she did recognize.
So that finding is clearly erroneous? Is that what you're arguing?
In Mother's opinion, that finding was clearly erroneous. Okay. Your Honors, this is a difficult case. Mother respectfully requests that you vacate and remand for further fitness determinations. Thank you, Your Honors.
Thank you very much. Very helpful argument to us. We will hear now from Attorney Papirio.
Good morning. If it pleases the court, Mark Papirio for the child P, the older child. I just wanted to touch on the Justice's last question about working on her own issues. And I wanted to, it's sort of a sister point to what was asked about, which was the judge faulted Mother for not having any insight in regards to the mental health episodes. And I wanted to say that there's a very important exception to that. The last one, the one that led to the removal of the children, the mother was able to say, I realized that my older daughter, P, was traumatized by having to witness that.
Well, she said traumatized by what the police did when they sedated her, when she tried to jump out the window, right?
I think it went as far, Your Honor, as saying as to she was traumatized by what she witnessed. So she.
Can we talk about your client?
Of course. Your
Honor. I mean, I don't want to interrupt your argument if you have things, and we'll give you additional time if we need it. The change of position is, at least to me, I don't know about my colleagues, is of real interest to me.
Judge, it wasn't explained to me by counsel. I just, they contacted me and they said, we have a case where, child has changed her position, and that's why you don't have a brief, because she's no longer within the timeline.
Have you met with your client?
I have met with my client.
In person?
Yes.
How recently?
I saw her last week, Your Honor. So she's 6th grade. She will she'll be beginning 6th grade, or she's just beginning 6th grade. She's 11 years old, and she would like to go home and live with her mom. That's her position at this point in time. And I was going to ask at the end of the argument for another type of relief. I just had a couple of points, if I could go into those.
Please.
Thank you. Your Honor, my brother, representing the younger child, F, talks about we can't really use the case law, the doctrine that a parent might be fit to parent one child but not another child, because that's really talking about one child is the subject of a petition and one is not. And I don't know why that could be extended to look at two children that are in the same, both subjects of the same care and protection. And I think this is a case in point. The judge incorrectly three different conclusions of law. She says, you know, both of these childs have very extensive special needs. But in her finding number 66, she said, with P, she has no unusual medical needs, she has no behavioral needs, she has no health needs, she's doing well, she's an autistic child. Her sister, on the other hand, has some very disturbing behavior. It's something when you're that young a child and you're being expelled from daycare programs over and over. So I would argue that with the mother's gains, as pointed out by sister counsel, that she is fit to parent her older child at this point in time.
Let me ask you about that. Actually, I'm going to ask you a couple things that are outside the record. I found, although I found the things about the judge's decision compelling, I found it very light on information about the children.
Mm-hmm.
So all it says is that at the time of trial, the oldest child was in a kinship placement.
Judge, she's with an adult cousin, and obviously this is outside the record, but that's what you're asking for. She's with an adult cousin. Both children were there at one point in time. The younger child is no longer there. This lady would adopt, but some of the information I wanted to point out to the court was that my client will be 12 years old in 8 weeks. She will not be agreeing to an adoption, I can tell you that. She'll be vetoing any kind of attempt to have her adopted. I think that the relative would be willing to do an adoption, but...
So at the time of trial, there was no evidence of that. There was evidence that when the social worker had asked early, and I know your time is up, but I have some more questions for you. At the time of early in the process, the person had been asked, is this the same placement she was in at the time of trial?
It is the same placement,
Okay.
you know.
So that person had been asked about adoption, was not interested early on, but hadn't been asked in a long time. And I don't know what the situation is with guardianship, and I don't know what the child's second choice is, but have you thought of bringing a motion for reconsideration before the trial court?
One of the things I'm asking the court to do today is to vacate the termination and remand for a hearing on fitness for mother, but also...
On fitness? The termination is different from fitness.
Yes, I understand, Your Honor, but also, to your point, to remand for a hearing on either greater post-adoption, greater post-termination contact, because my client's position, if she cannot live with her mom, she wants to see her much more than the 2 visits that the court...
And that's what's going on right now? It's 2 visits a year?
It's 2 visits per year by order of the court.
I think that, no one else has custody. So this kinship person can't increase that. It's all up to DCF, is that right?
Yes, because the department is still the custodian.
I understand.
And this lady would be willing, I think, to entertain a guardianship, but or even adopt, but that's not what her ward is looking for.
So I guess and others may have questions for you, but I guess my last question is, you say that, and I agree, there's an error about these special needs in what the judge said in a couple places. If the mother has been predicted, and if this is supported by the judge, that she's going to continue to have episodic, I don't know if they're psychotic episodes, but whatever they are, episodic episodes that put the children at grave risk, followed by hospitalizations that then require disruption and placement and so on, how can we conclude that she is fit as to either child?
Well, That's an educated guess, Your Honor. I'd say that's all it is. How can we put a continuum on rights are terminated and this may never happen again?
Well,
Some of these episodes,
because someone has to make a judgment about the stability of the children, and the question would be, is it is it clear and convincing evidence that it's likely to continue into the future if it's happened 8 times in 12 years? And the things that preceded these hospitalizations are terrible.
I agree. And my client, again, is not an adult, but she has seen at least 2 of these, and she's willing, and...
She can be willing. She's 12 or 11, and she...
This is why I preface that, Your Honor, but she believes that if she were back in the home, things would... she'd be able to deal with that, and her mother as a family, and that's what she's asking the court to consider a remand, either as to fitness or, as I mentioned before, a hearing on increased post-adoption visitation. Thank you.
All right. Thank you very much for your time. Of course, we appreciate it, and it's very helpful to us. We will hear next from Attorney Bayless.
Yes.
Superb.
May it please the court, Jeremy Bayless for the Department of Children and Families. This is a case with a mother who has had long-standing, chronic, and repeating mental health crises. And while she had been in, as the judge noted repeatedly, a better place by the time of trial, the judge also found that her testimony at trial was concerning and indicated that she still had not fully grasped the impact of her mental health and what is necessary in recovery. She had testified that her children were only exposed to sort of the consequences of her mental health or the effects of her mental health one time over their life, when that was obviously not the case. She had, she was continuing to talk about how the grandmother was conspiring against her in some capacity with unspecified other people. So this isn't a case as it's presented where mother was sort of free and clear of indications that her mental health was still a risk by the time of trial. She was doing better, and the judge credited that, but it was still clear that she was not out of the woods, that it was not a problem that had been remedied such that the children would not be at an unacceptable level of risk in her care.
To the mother's point, was guardianship ever considered as an option here?
It wasn't put forward as a plan. I can't speak to any discussions that would have happened, particularly afterwards. Obviously, if the older child is unwilling to consent to adoption, the department is not seeking to have her stay in the department's care until she's 18, just for the sake of it. I'm sure those conversations will happen or would happen. Similarly, in terms of post-adoption contact, sort of going into the more current state of things, if the older child
Can I ask you about that?
Yes.
I've never had this circumstance. If we affirm the judge's decision in whole, and the oldest child refuses, doesn't want to be adopted by her current placement, what happens?
She would, barring any changes, she would remain in the department's custody. If she's refusing adoption, then it would sort of be on the clinical team to find a solution. Their solutions could include working towards a guardianship or working towards, there kind of aren't that many other options, but working towards a solution that would get her to a stable, permanent living environment where she would be safe. It's also, she's going to be 12. A lot of time between 12 and 18. It may be the case that as progression goes through, as she spends more time away from that volatility, that position might change again.
And of course, you can limit her to 2 visits a year.
Well, we can now. Obviously, the child
Yes,
has
but
the
if you remain in custody until she's 18, you can for the next 6 years, right?
Unless, of course, child's counsel goes to the juvenile court and asks that that order be amended, as they have every right to do, and could do as soon as this decision is affirmed. The child has the right to go back in to ask that that order be amended, and a change of circumstances, a change of position would certainly provide grounds for them to do that. And also, if mother continues, there's nothing precluding the department from increasing visitation.
But you haven't so far.
Not to my knowledge. I limited my review to the record. I didn't want to go outside of it, but not to my knowledge. But that is certainly a relief that can be granted by someone other than this court finding error in the lower court's decision where there was none.
Do you agree that there was an error in the findings about special needs for both children?
I do need to rephrase my, there was that error. That was an error. That the court explicitly found that the older child had normal child that age needs. The younger child was the one who had the more extensive needs. That concluding otherwise was error. However, I would argue that error is harmless because while the mother, a central portion was the mother being unable to meet her children's needs, I think it's pretty clear that that is the needs of any child. It's the needs.
Well, we should probably ask the trial judge to clarify that then.
I don't
Why
believe,
put in can't meet the special needs of both of them if she can't meet the needs of anyone?
I'm sorry, Your Honor.
Why did the judge put in that she couldn't meet the special needs of, let's take the one that's in error, of the oldest child? Why is that in there if those special needs have nothing to do, if special needs has nothing to do with the decision?
I'm not sure, but I do know that when you read the conclusions, the judge very clearly concludes that this mother cannot meet the needs of any child in her care. There's no amount of lack of needs that would make a child safe when mother is going through the episodes that she's going through.
I'll ask your colleague, but as I said to your other colleague, the findings about the children are very light in this decision. You know, usually a decision would have a section going through every medical record of, you know, the children, and that isn't here. But it is, well, but at the time of trial, the child was in a residential placement, is what it said, which I take it means some kind of institution, not a foster home.
Yes,
Is that right?
I believe so, yes.
Do you know if she's ever left there?
I do not.
You literally don't know. I know it's outside the record, but you don't know.
No, I do not know.
Okay.
And so the question that the judge had to answer is that they are presented with a parent who has had 12 years of stability marked by violent incidents and then a return to stability. There's been 2 reunifications where mother has improved to the point where her children were able to be safely returned home, only for that to happen again. And so we're in a spot, and obviously the court is correct to worry about how much recovery would indicate actual recovery versus a continued risk. But that's where mother's testimony really comes in. It's difficult, I would argue we can't actually make a bright line, X amount of months, X amount of years, and you're better. But what you can do is defer to the finder of fact, who is the one evaluating the witness's testimony, and that's what those findings were about. They're about the substance and presentation of mother during testimony, indicating that she still seems improved, but not to the point where she understands what her triggers are in a way that she's going to prevent it from happening, where she understands that her behavior is what is harming her children, not the reaction of the police to her behavior. And that is something that the court correctly found is going to continue indefinitely. So even if there's not a clear answer as to what's going to happen immediately, what is clear is that these children are at an unacceptable risk of serious harm in mother's care, and they will remain at risk of that harm in her care indefinitely, such that termination was in their best interest. With regards to the findings, I think we touched on that briefly, but the unfitness is not such that the differing needs of the child, it's similar to Zygmunt, which I know is unpublished but is informative, that there's no child who would be safe in the environment that mother engendered. And with regards to the plan, one thing that impacted the plan, and also is an indicator that mother is not likely to recover soon, is that in previous hospitalizations and in previous years, mother has had extensive support from her family, and those family members have been slowly driven away due to mother's volatility. That was the finding by the court, that she was being hostile to them as well, and that was actually eliminating her support network, and that was part of what impacted, as of trial. I understand maybe positions have changed with one of the kinship placements, but as of trial, that was a limiting factor in recruiting family-specific or kinship resources, and so the department's plan was adoption. It was the only plan that was presented. This is frequently the case. It might have been preferable to have more detail, more specifics, but it's also the case that a wide net needs to be cast before narrowing it in. And that's also something that is impacted by termination. This court has acknowledged, and the department has frequently raised, that a termination makes it easier to seek adoptive resources. That it should never be the reason for a termination, but it is something that is impacted by it. I see my time is up, so if there are any further questions, I'm happy to answer. Otherwise,
thank you very much for an excellent argument. We will hear finally from Attorney McCarthy.
Good morning, Attorney Robert McCarthy for the appellee child. She's the younger of the two siblings, and she's 7 years old right now. She was removed from her mother's custody in April of 2020. She spent the majority of her life in DCF custody. She was placed back with the mother in April of 2022. That was 2 years after she was removed. And that didn't last too long. She was taken away from her mother again because her mother suffered a mental health crisis, which my client unfortunately did witness. I met with my client a few days ago. Her views remain consistent. She supports the decision of the trial court. She does love her mother, but mother suffers from a chronic mental health condition which has spanned over a decade, and it doesn't appear to be getting any better. This child is seeking stability and consistency, and that is something that this mother has not been able to provide this child. The child has been in DCF custody for the majority of her life, and despite that, she's been described as bright, social, curious, full of potential, but she does have some challenges that need navigating. And no child, and my client in particular, should have to navigate those challenges without stability and consistency, and that is what she's looking for, a loving home. But my client's issues are not at issue. My client's challenges are not at issue. What is at issue is mother's inability to take care of the child. And we would emphasize that in May of 2023, the mother stipulated that she was unfit. That was a short time before this termination trial took place in November of 2023. Also, the mother acknowledges in a brief that her parenting skills are a work in progress. With respect to the issues, a couple of the issues that the mother raises in a brief, as far as the judges having to analyze whether or not the mother would be fit to raise one child and not the other. The judge made it pretty clear. She issued 72 findings of fact based upon 125 exhibits totaling 1,000 pages or more, and testimony that spanned 2 days. She stated that this mother could not take care of any child, period. In addition, as far as the adoption plan is concerned, that's an issue specific to the child, not necessarily to the mother if it goes back it doesn't necessarily, it's not going to reverse the decision terminating parental rights. It might just give the judge an opportunity to write more facts. But in my client's case, what she was looking for is a judge to make a decision that an adoption should go forward. And that plan accomplished that. It wasn't an abuse of discretion. The judge made a reasonable, prudent decision that put my client on the path to getting the permanence that she wanted, that she needs.
Does she remain in a residential placement?
No, she's not. She's in a pre-adoptive home.
She's in a pre-adoptive home?
Yes.
Great.
And my client has an absolute liberty interest in living a childhood that's free from abuse and neglect. And that constitutional right is unconditional. Childhood is also fleeting. And my client entered care when she was 2 years old. She's going to be 8 years old in a few months. So the court properly focused on my client's right to be free from chaos and disruption. And that's exactly what would happen if my client was placed back with the mother. She'd be subject to that chaos and disruption again. So
You have no concerns about the 2 visits that are currently the minimum? You have no objection to that?
There's no objection to that, Judge, for the simple reason she does have trial counsel, and the other reason is I believe that the findings usually give the adoptive parent the discretion to increase the visits if necessary. My client does also visit with her siblings once a month, so that's good. She's happy about that. If there's no further questions from the panel, we'd rest on a brief.
Thank you very much. Very helpful argument by all of you. These are our toughest cases as a category. So there's a lot at stake. So thank you very much for your very excellent help. The case is submitted. The final matter we will hear today is partially impounded. I remind the counsel not to say anything that's impounded. It is number 241265, Cresta v. Cresta. And we will hear first from Attorney Rutecki.
Thank you, Your Honor, and may it please the Court. This case involves the application, or should I say the misapplication, of the provisions of the attorney's fee lien statute, General Laws, Chapter 221, Sections 50 and 50B. It has a most unusual procedural history, but the fundamental issue is whether the allowance of the motion to enforce and establish and enforce the attorney's lien, that is the motion that was partially allowed, if by that partial allowance my client, Mr. Cresta, was denied his right to trial by jury.
So can we talk about your appeal from the order establishing the lien?
Yes.
That's the first piece. So let's set aside the argument about whether or not you had a right of interlocutory appeal, right? Let's assume that that's not an issue. The divorce judgment, you had to appeal it by the time of the divorce judgment, didn't you?
Correct, yes. So
and the divorce judgment entered in December 2023. You filed your notice of appeal, in this case, in September 2024. You filed it after the contempt judgment, but that's a different proceeding. So why is your appeal timely as to the order establishing the lien?
Yes. So as you said, the divorce judgment was dated December 8th. The notice, and there was a motion to alter amend. The notice of appeal of the divorce judgment was filed March 1st, 2024. There has been no, at this time, the notice of assembly of record has not been issued.
That's a different case, though. That's a different
Beg your
appeal.
pardon?
That's a different appeal.
It
It's
is
not
a
this
different-
appeal.
it is a different
So
case.
we can't rely on a notice of appeal. And I don't know what's in that notice and whether the underlying order was challenged or not. That seems like a different issue. We're stuck with the notice of appeal.
Right. So there are two things. So the first is the divorce judgment made no reference whatsoever to the motion for attorney's fees. No findings of fact regarding it. No,
You mean the motion, not the parties' motions. You mean the motion for a lien,
Yes.
right?
Right. So the
Okay.
allowance, in other words, it wasn't incorporated. And as you recall, the motion for the lien was
I'm surprised to hear you making this argument. I looked at the single justice matter.
Yeah.
Justice Sachs asked for an explanation of why this appeal was timely,
Yes.
and you filed an explanation
Correct.
that said there was a Rule 59 motion timely filed that stopped the appeal, notice of appeal from being due, and that within 30 days of the entry of the denial of that motion, you filed your notice of appeal.
Correct.
Isn't that the whole answer here?
No, I don't think so. I don't think so, Judge. I don't think so. And
You
so-
don't think that's why you have a valid appeal here?
Okay. So I would. That's part of it. Okay. So I know you're. I understand what you're saying. This is so. In my reply brief, I made reference to a statement in the appellate practice, mass practice series. And in that, the author states that a notice of appeal that identifies the final judgment, and we've identified the final contempt judgment, will support the appellate court's review of all interlocutory orders that culminated in that judgment. So
I can't understand. You're saying that the notice of appeal from the contempt action, a separate action in which there was no interlocutory order except, well, there's no interlocutory order. There's the four things that either are allowed to be in there or aren't.
Right.
I think the question is intervention. You're not challenging the interlocutory order during the regular divorce case?
Well, no, we are. We certainly are.
And
But-
how do you challenge that? Why is that appeal timely? I think that's what Justice Toone is trying to figure out.
Because just as I said, that the temporary, that order, the May 31st order, allowing the establishment of the lien but not the enforcement, that is the order that culminated in the issuance of the contempt judgment. The judge
I'm
writes
sorry.
right in
If that's your argument, then I don't see how we have jurisdiction here. Now, we have to sua sponte look at it. But I cannot, were you involved in the case when that explanation was filed with Judge
Sure,
Sachs?
I wrote it.
Why are you not saying that the first order was brought here by that appeal? And that, I'm not sure which appeal we have before us, by the way, but why aren't you saying that was brought to the appeals court by the first appeal? And then the pieces of the mistaken, by your accounting, pieces of the enforcement were brought here by the contempt appeal? Why are you focusing on the contempt appeal in which clearly the May 31 order was not an interlocutory order?
No, because it's incorporated. In other words, as I said, the appeal includes.
You're making it awful hard for yourself here.
Okay.
Unless there's a reason you don't want the appeal from the final judgment in the divorce to bring it here, which I think it did.
Well, it has, but we haven't filed the briefs in that. In other words, I think that we have appealed timely from that order because.
And where is that appeal? It is not, the record hasn't been assembled yet.
The record hasn't been assembled, but the notice of appeal.
Did you move to consolidate the appeals?
Could I move? I assume I could do that.
Or to stay this pending that? Because either there is a legitimate order putting a lien on, or there wasn't a trial by jury, so there wasn't. And I think that's in the first appeal. I don't see how what we're reviewing is the contempt judgment. Now, we do have I agree, we have these orders, but I think we have to stay it if you don't ask us to let someone figure out if that appeal is proper.
And if that's your decision, obviously that's your decision. But what I'm trying to get at is, even at the stage, and I'm not trying to cut my nose off to spite my face here, but you're asking me, why do I think it's incorporated in the contempt appeal?
Yeah.
In its phase at the end, after the divorce judgment was issued, it still remained an interlocutory order. It hadn't been completed.
Oh,
The
the fact that it's not referenced in the final divorce judgment, I don't think makes a difference in terms of that's the time, when you get a final judgment, that's the time which you have to appeal a prior interlocutory order. So the fact that there's no requirement, I think, that a final judgment sort of reference all the prior orders. It's up to you to sort of say, I'm appealing from the divorce judgment and these orders that came before it, right? And so, can I just mention one more thing? I mean, another problem with your challenge to the order establishing the lien is that you don't include the hearing transcript, right? You're essentially saying, I was denied an evidentiary hearing, I was denied a jury trial, and there was a hearing on that order. It's not in the record. So if we had jurisdiction with a timely notice appeal, I'm not sure how we could possibly review this issue without the transcript. That's something to consider if you're developing the record in the other appeal, where this may be a live issue. But it does seem like you do have a live issue as to the enforcement order that was in contempt, because you did file a timely notice from that.
Yes.
Unless, I don't want to jump ahead, but maybe we should talk about that issue.
So the way that Attorney Bagley tried to enforce it was by filing this motion to intervene in a contempt case. And intervention should be allowed, or intervention can be of right and it can be permissive. As of right, she has to establish that she has such an interest in the outcome that it would impair her right to defend or protect her interests. And in this particular case, the contempt was an action to pay attorney's fees to Mr. Cresta's first wife. Attorney Bagley had no interest in that whatsoever, and the payment of fees to the first wife did not impair any of her rights in any way. Keeping in mind at that time, all she had was a motion from a judge saying, well, he owes you $130,000, but there was no actual lien ordered. There was no property interest identified from which that was to be paid. So,
isn't your, I know you make an argument on intervention, right? And that's a complicated issue because maybe there was an interest in priority or something like that. It seems like the fundamental problem that you have with the enforcement piece is that it wasn't done in the Superior Court.
Correct, absolutely correct.
So that's your central argument, right?
So by the time she filed her motion to intervene, the divorce case was over. The judgment had been issued, the nice-side period expired, there was no case pending in the probate court. And the statute, Section 50, is very clear, saying if there's no case pending in the probate court, then she must go to the Superior Court. And there is a case, the Neuwirth case that I cited, which reaffirms that clearly. So that is a grounds. And also the intervention should not have been allowed. There was no permissive intervention. There were no common issues of law, in fact, in the contempt and in the attorney's fees. The only thing that was in common was the word attorney's fees. So on that ground, that motion to intervene should not have been allowed. Finally, in the judgment for contempt, the probate court judge issued the lien on assets that were subject to execution. She ordered it was his home. He owned his home, and the Supreme Judicial Court in the Elbaum case, clearly stated that the purpose of the statute was to, or the second component, the equitable component, was to lien property rights that could not be reached upon execution. And his home was clearly something that could be reached. And in so doing, as I said in my brief, Judge trampled on all of Mr. Cresta's protections and statutory protections for executions and levies and attachments, supplementary process, all of that. So,
I thought that the lien was on proceeds from the case,
So
Isn't that all a lien is on? Is the house a proceed of this case?
So the way I would answer that question is the statute says an attorney has a lien, a general and inchoate lien, as I believe the expression that is used. But in the motion and in the judge's allowance of the motion, she never said what proceeds would be liened.
I thought there was case law that it was about the proceeds of the lawsuit, that it was taken out of whatever the lawyer had won for the
Yeah, so that typically it applies to cases where there's monetary damage.
Yes, of
and
course.
that monetary damage isn't subject to execution. Okay.
And where do I find the rule that it has to be something that's not subject to execution?
That's in the Elbaum language, and it's cited on.
No, I'll look.
Cited on page. In fact, it's quoted in the very first section. I think it's page 17 of my brief.
But the statute has been interpreted to protect an attorney's interests within the context of a legal proceeding that doesn't necessarily generate a monetary judgment, right? I mean, that's what the SJC held in the Ropes and Gray case.
Well, again, my complaint with what the judge didn't identify anything. You know, she didn't say, okay, in the motion, the money that the wife owes the husband, that's liened. She just said allowed as to the establishment, which really meant allowed as to the amount that's owed. And by the way, that amount was determined without, it was clearly a rubber stamp.
Does that issue go back to the order establishing the lien?
But your position, if I understood what you said before, is that to eliminate what you say are wrongful paragraphs of the contempt order, your first argument is because it's based on an invalid lien.
Yes.
And therefore, we look back to see if this lien was valid, and then you say, and there was no trial by jury.
And respectfully, the commentator that I cited in my brief states that all interlocutory orders that culminated in the issuance of the final judgment are reviewable.
Oh, okay,
So
but that's different. That's the other judgment. I'm trying to figure out if in the contempt judgment, because I don't believe it's an interlocutory order in the contempt proceeding.
That is correct, but it did culminate in the contempt judgment.
Right, but the principle that you can attack the underlying order, that's a rule about contempt orders, right? This only happens to be in the vehicle of the contempt proceeding, but there's not a rule necessarily that says if you have if the determination of a lien and the enforcement of a lien are separate things, so you get to at the enforcement stage go back and re-question the determination. You don't make a case on that, right?
That's correct.
You're kind of just extrapolating from the principle in the contempt.
Yes.
Okay.
All right. So my time is up. Thank you, Your Honors.
More questions?
Oh, no.
Okay. Thank you very much. It's a very interesting case, so thank you very much. We will hear next from Attorney O'Regan.
Good morning. May it please the Court. My name is Robert O'Regan. I'm here on behalf of Attorney Martha Bagley.
Counsel, I'm going to hit you right off. Sorry. Why did the probate court, have jurisdiction to even hear anything to do with this lien? Should have been in Superior Court. The case was over.
The case was not over. I have to disagree with Your Honor. The motion to establish attorney's lien was filed before the divorce judgment was entered. The order establishing the amount of the lien was entered before the divorce judgment was entered. Under the provisions of General Laws, Chapter 221, Section 50, the trial court before which a case is pending has jurisdiction to determine the amount of the lien.
So you're saying
up through
the divorce,
entry.
But aren't you parsing out the lien almost like it's a different proceeding than the divorce? Doesn't that swallow the rule? If
No.
under your theory, every time you file a lien in a case, it's a new proceeding, then the underlying action has no relevance. And that would make the statute irrelevant.
The attorney's
I see
lien,
your, am I understanding it right? There's the divorce proceeding. There's a lien put on during that proceeding. And you're saying that even though the divorce proceeding ended, the lien proceeding is ongoing?
no, the lien proceeding. Let me back up and start with the statute.
Okay.
The statute, and I'd refer the court to the Boswell case, the statute contemplates a two-step process to protect attorneys, as the SJC said in Boswell, quoting Judge Cardozo, which is always a thrill to quote him, against the knavery of a client. And so up through and including, in the family law context, the entry of a divorce.
Why are you using the word "in the family law context"?
Because
I saw that in your brief
judgment.
also.
It's a divorce judgment. This is a divorce case.
Yes, I agree with that, but why would the rule be different in a family law context than any place else?
Frankly, it wouldn't, but I'm applying that to this particular case.
All right.
We have a divorce case with an attorney who, under the statute and under the case law, had a charging lien as a matter of law against everything, any potential recovery under the judgment that Michael Cresta may have received. And that inchoate lien then was converted into a coate lien once the judgment entered.
So now the first case is over, right? The divorce case is over when the judgment enters. But if the divorce case is over, don't you have to bring your action in the superior court? Or
No.
you're saying suddenly if you bring a contempt judgment, it isn't really over?
No. The statute contemplates that until the divorce judgment or any judgment in any trial court department where an attorney participated on behalf of a client up through and including entry of a judgment in that case, that trial court has jurisdiction under the statute to determine the amount of the lien.
So you're saying that what we have to look at here is the order, the May 31 order that determines the judgment. You want us to look at that.
Yes, my position is.
Okay, so if we find, then let's talk about, although maybe that's not.
I'm completely lost. You've completely lost me. Because under your argument then, back to what I said earlier, when an attorney files a lien, it's always ongoing. It never ends until there's a judgment on that lien.
Actually, the lien never ends until the lien is satisfied. There are two stages what the statute contemplates.
But then what does Neuwirth mean? You're ignoring...
Neuwirth means, this gets to what I was trying to say to Justice Rubin. Neuwirth means in a divorce case, up through entry of the divorce judgment, in that case, the trial judge was Judge Gibson. Judge Gibson had the authority to determine the amount of the attorney's lien. She didn't do that. Instead, a judgment of divorce entered. The amount of the lien was determined after the entry of the divorce judgment, and she amended the judgment to include the lien. And the outcome in Neuwirth was, once a final judgment enters...
Wait, there's an amended judgment?
Not in this case, in the Neuwirth case.
The
error in the Neuwirth case... The error in the Neuwirth case was that in that case, the trial judge determined the amount of the lien after the divorce judgment. In this case, the amount of the lien was determined before the divorce judgment.
Yes.
And pursuant to the statute, the trial judge had jurisdiction to determine the amount of the lien.
So you're saying that the establishment of the amount of the lien vests jurisdiction with everything having to do with that lien in the probate court?
Up through entry of its judgment. If this were a district court case, a district court judge could do it.
So what about enforceability of the lien?
That's a separate action. That's a separate matter.
That has to go to Superior Court?
Not necessarily.
Something has to go to Superior Court according to the
It doesn't, no, because the lien amount has been determined. There's two stages to this. The analogy I would suggest would be a mechanic's lien, any other kind of lien. Every lien does not need to be enforced through judicial process. It can be, but it doesn't need to be. In this case, the statute, and I refer the court to the Boswell case, 414 Mass at 248, and this deals with some of my brother's comments on the Elbaum case. In other words, the attorney's lien grants the unpaid attorney a tool for recovery of legal fees which surpasses in effectiveness a traditional action in contract or in quantum merit. And so in this case, what occurred was, while it was pending between the parties, Mr. and Mrs. Cresta, Attorney Bagley timely brought a motion for that judge in the trial action to determine the amount of her lien. Within the statute, the probate court judge had authority to do that, and she did.
I'm with you.
The next
No,
question.
Whoa. She brought a motion to establish and enforce the lien. The judge said, okay, I'll establish the lien, enforcement's a different proceeding,
Yes.
right? So that, I know, hypothetically, maybe the judge could have established and enforced the lien in that proceeding, but she chose not to. So the question then is left, where do you bring the enforcement? And I think it's very clear under the statute, under Neuwirth, you got to bring it in Superior Court. How can you possibly bring it in a separate contempt proceeding?
Well, I don't view the contempt proceeding the way my brother does. I view the contempt proceeding as anticipating some of the difficulties that would accrue, which we talk about in our brief. So the statute granted Attorney Bagley a charging lien against everything that Michael Cresta did recover under the divorce judgment. That included anything he would have gone to a bank to mortgage in order to discharge an obligation to pay cash, whatever it was, to his ex-wife. Now, in order to achieve that, Attorney Bagley's attorney's lien was in the way.
But I know you're making an efficiency argument, like it was efficient to sort of process the enforcement of the lien with the contempt. I get that, but we have to follow what the statute says, right? It might have made sense objectively or from an efficiency standpoint, but the statute says if once the proceeding is concluded, you have to bring in Superior Court. It's either the original proceeding or Superior Court. Those are your two choices. And so the divorce judgment ends the divorce proceeding. The contempt, a complaint for contempt starts a new proceeding that culminates in the contempt judgment. But you can't enforce the lien in that proceeding because it's not the Superior Court.
I'd ask the court to read what the judge put in the contempt judgment and the direction given. There was a special master appointed, and the special master was charged to liquidate assets of Michael Cresta to complete the division of the marital estate.
What were the common questions of law or fact that allowed you to intervene? Not common questions of ease or helpfulness, common questions of law or fact.
How does a special master appointed to liquidate assets held by the husband, in which an attorney has a priority lien under the statute, how do those assets get liquidated to satisfy a judgment?
He was supposed to identify the assets. Was he supposed to liquidate them?
The issue in the contempt was money was owed to Mrs. Cresta. The plan that Michael Cresta came up with was to get a loan against some of the property he had received in the divorce judgment, over which Attorney Bagley had the statutory attorney's lien.
What was the special master supposed to do?
The special master was supposed to actually sell assets awarded to the husband in order to satisfy.
What other assets aside from the house were awarded to the husband?
He had a business interest, he had vehicles, the judgment is in the record, he had
Okay,
substantial
so
assets.
if you can't sell the house, then I guess the other stuff will have to be sold.
The attorney's lien attached by operation of law.
It's got nothing to do with the attorney's lien. right? The $80,000 or whatever it is that was owed to the wife has nothing to do with the attorney's lien.
I have to disagree and ask Your Honor to consider the only place Michael Cresta could come up with that money was from assets he had been awarded in the divorce
And you said
judgment.
they include business interests, cars, and the house.
And the attorney's
Oh, you're saying the
lien
lien is on all of that
is
stuff?
on everything.
I see.
And that's really what Boswell says, is the lien is on everything.
Can I ask you this?
That's it. by
In a
operation of law.
challenge to this enforcement order, is it a good defense the lien that was put in place illegally or wrongly?
I'm sorry, I couldn't hear you.
That's the first time that's ever happened.
What do you mean by ear?
I don't know. It's in this enforcement action, through the mechanism that you're describing of using the intervention, which is a separate issue, in that action, would it be a good defense to that action? This lien is unlawful. It was put in place wrongfully. There's no lawful lien on my...
No, because that lien existed even if Attorney Bagley had not received the order dated May 31 to determine the amount of the lien. By operation of law pursuant to the statute, that lien was in place. Unless the attorney's lien were satisfied.
Okay, the lien, the $130,000 amount, though, was determined.
Yes.
Okay, and he can't challenge that. You come in and enforce and say, I want $130,000 because of this May 31 order, and he says that May 31 order is invalid. It was issued unlawfully without proper process. You can't enforce that against me. Is that a valid defense or it's not?
No, there was no notice of appeal taken.
I didn't
from the May
ask you
31
about the
order.
notice of appeal taken. I'm asking about in the contempt action, where you come in and say, I want the 130. Can he come back and say, the lien that says 130 is invalid?
No.
And that's because he can only do that how? How can he raise that in appeals court?
The order entered May 31
I agree.
was an order entered in a separate subsidiary action to the divorce case. Mary Cresta was not a party to that. Martha Bagley is not a party to the divorce.
If I can follow.
Oh, yeah, please.
You assert, you may ultimately win on the notice of appeal issue, but not for the reasons you put in your brief. You say that the husband had to appeal within 30 days of the order establishing a lien. Do you have any case that says that? Or is that you're just sort of assuming that this was an order from which you could take an immediate interlocutory
Our
appeal?
position is that was under the doctrine of present execution that that
Do
was
you have any case saying
that
that
was
in the
we
attorney
cited them in our brief.
Well,
This-
you use the phrase present execution.
Do you have any case saying present?
There is no case we could locate
Okay.
on the attorney's lien statute.
Okay.
That
And
would-
even if it was immediately appealable, that still doesn't resolve because Appellate Rule 3 sort of says the fact that you have an immediate appeal doesn't mean necessarily you can't appeal after final judgment. So you don't have any case saying either you could appeal it or that you had to appeal it, right? You're just sort of, you're arguing that, but there's no actually authority for that as far as you can.
Actually, I'd refer you to the cases in our brief, Commonwealth versus Bruno, Brault versus the Board of Fire and Commissioners of Springfield.
Those attorney lien cases?
Aldred, well, there are no attorney's lien cases
okay,
that we could
that's what I wondered.
find on this issue reported up, that is, but the attorney's lien proceeding is a subsidiary proceeding within the divorce case. The determination of the amount of the lien is a final action on that.
It's a final judgment?
It is a final order, and
It's a final judgment
it
that
is
is appealable here?
Yes.
Did a separate order of judgment enter? Because I didn't see that.
No judgment.
Usually when a motion is denied or allowed, it's a motion in the case. It's not a separate and final judgment. Now, if you think that something is a separate and final judgment, you can ask the judge under some rule of civil procedure to enter a separate and final judgment on that so it can be appealed immediately. Otherwise, it's a piecemeal appeal.
I understand, but our position is it's a final order for appeal purposes.
Final order.
Final order for appeal purposes. This is a particular creature of statute. The statute does not
Well, the
say you
statute
will file a complaint.
doesn't create the motion practice that, I don't know if it was you or a different lawyer engaged in here. Lots of times there are petitions, I've seen that, for an attorney's lien. Sometimes an action, it's a separate cause of action and it's brought somewhere. I'm not saying you can't bring a motion, I'm just saying it doesn't seem like when the motion is denied or allowed, it's final judgment.
Well, as you look at what occurred here, was it a final determination under the statute of the amount of the lien? Yes. What was the next step? Execution.
No.
The answer?
If you're done, just one more question on the merits of that argument. The attorney, and this may have not been preserved, this may not have been adequately presented to us, but just assuming the questions before us, the attorney says, look at Elbaum versus Sullivan. It says, I have a right to a jury trial in connection with the establishment of a lien. And you don't really mention Elbaum in your brief, you kind of gloss over it. Doesn't that authority stand for the proposition that, at least with respect to the establishment of a lien, that there is a jury trial right?
So your question, Your Honor, it really has two parts. The lien is established by operation of law. The question is to determine the amount of the lien.
Okay, is there a jury trial as to that?
So, and the statute further provides, and I believe it's section 50B as opposed to 50, that if a division of the trial department has authority to determine legal fees, that court may so determine. And so that is why in our brief, we refer the court to the plenary authority of the probate and family court in a divorce case under General Laws, Chapter 208, Section 38, to determine legal fees.
So that's the legal fees of the parties, but there's a right to trial by jury for an attorney's lien amount. Isn't there? You don't mention that there isn't. Anywhere you don't say it's distinguishable or why these cases apply. You just cite some attorney's fee case, and of course we know that judges can we determine attorney's fees in cases where we award them either because of the statute or...
And I appreciate I'm well over time. I'd answer that if I may.
Please keep answering.
Number one, there was no timely appeal, so even if that were an issue, it's been
got it. What's your answer as
Number two is, under General Laws, Chapter 208, Section 38, our position is that applying what the legislature wrote in Sections 50 and I believe 50B on the attorney's lien statute, the legislature contemplated that there is that if it has granted authority to a department of the trial court to award attorney's fees, that court may award notwithstanding the jury trial.
Let me try this one more time. Why doesn't Elbaum say the husband was entitled to a jury trial?
Because the statute says if the legislature...
Elbaum was interpreting the statute.
Pardon me?
Elbaum was interpreting the statute.
Elbaum was not interpreting the statute that granted authority to a different court that does not have jury trials to award attorney's fees.
50B says, the court shall determine all claims in a summary manner, but without abridging the right of trial by jury as guaranteed by the Constitution. So how does that give plenary authority to the judge?
I'd submit that because Chapter 50 itself authorizes a division of the court that has authority to set fees to do so, and that's what this court did. And I come back, I'm sorry to keep harping on the point. If that were a live issue, it needed to be preserved by a timely notice of appeal taken from the order itself that entered May 31st.
Well, is
or
it an issue?
docketed.
Is it an issue in the other appeal? Because he appealed from the judgment in that case. So can he raise this issue in the other appeal?
I'd say Attorney Bagley is not a party to the divorce case. It's not an issue in an appeal from the divorce judgment.
Did he file a notice? He filed a timely notice of appeal from the divorce judgment.
But Attorney Bagley is not a party to the divorce. Attorney
Well,
Bagley...
then it was a funny place for her to bring her motion, wasn't it? In a case she's not a party to, that's a weird motion. I've never heard of a non-party bringing a motion.
And, Your Honor, that is the basis of our argument that the proceeding to determine the amount of the attorney's fee is a separate subsidiary independent action within the divorce. The amount determined on the May 31st order is a final order which was appealable when it was docketed. No
What
notice
case
of
was
appeal
it
taken.
decided in? It was decided in the divorce case, and you just told me she's not a party to the divorce case.
It was a subsidiary action within the divorce case.
Give me a case that calls a motion a subsidiary action in any context. I'm ready to hear it.
May I submit a 16L letter with that?
If you can find it, you can.
I will look.
And you can respond to it if he finds it.
Can I go back to something? I'm sorry. You filed, or Attorney Bagley filed a motion to intervene, and I sort of understand you're seeing there's a pool of money. You want to make sure that that pool doesn't dissipate before the attorney gets paid. I understand that. But wouldn't the proper thing done would have been to stay disbursement of those funds and go to Superior Court for enforcement of the lien? Because that's what the statute contemplates. The statute says if the proceeding is over, you go to Superior Court. Wouldn't that have avoided this issue? You can't give out all this money because we have the money. Let us go to Superior Court and prove that we have this money.
And there's a lien. If he tries to sell it, he's not going to be able to.
So here's the procedural quagmire that existed. There's an order entered by a divorce judge appointing a special master to sell assets to satisfy a judgment.
Mm-hmm.
Attorney Bagley does what? As Your Honor suggests, goes to Superior Court, gets an order from a Superior Court to stay compliance with a probate court judge against a special master?
Or go back into the probate. I mean, you filed a motion to intervene in the contempt. You could file a motion to intervene and say, stay the disbursement of the funds because I have this money owed to me.
Or if someone tried to sell it, no one's going to buy it because there's a lien on it. That's how liens work, right? You have a lien on it.
Or the divorce judge could say, as she did, I had established an amount of a lien. The lien is a coit lien over all of the assets. That lien has not been challenged. The time for appeal from that lien has expired. Before the special master disposes of assets, that lien has to be satisfied. In any case,
so everything turns on whether that lien was appealable after final judgment. Everything. Because if that wasn't a final judgment, there's an appeal pending, right?
There has been, as I look at the record, there has been no appeal taken.
Okay, I hear you. So, and that is what your case depends on.
That is our first argument.
Okay, not just your first argument, because if there's been an appeal, then you don't have a final anything to go in and, well, maybe you can enforce it before the appeal is heard. I don't know what the rules are about that.
And the lien still exists by operation of the statute.
The amount of the lien, well, all right.
The lien still exists.
Thank you very much. As you can see, this is a case that interests the panel a great deal. Thank you both for your arguments. The case is submitted. I'd like to thank the court officers and the court staff for their assistance during this hearing, and we now stand in recess.
Court, all rise, please.